Hello again, this is the second section of this seminar, and this section deals with searching, the register of inhibitions and some practices around searching. So I thought it might be useful to again go back in time a little and look at some aspects of searching that caused difficulties prior to the coming into force of the 2007 provisions. So the property that you can see behind me here is 68 Hamilton Place, Aberdeen, and it features in one of the cases that caused a great deal of difficulty in the 1990s. And that case was Atlas Appointments against Tinsley, and the citation I've given you here is 1997 Session Cases 200. The point at issue in the case was quite a narrow one, and it turned on the difference between the debtor's name as it appeared in his titles, Stephen John Tinsley, Stephen with a PH, and how he was known as a director of Atlas Appointments, and there he was known as Steve Tinsley. Tinsley and his partner sold 68A Hamilton Place, Aberdeen, a flat at that address, and for Scottish searchers were instructed. They failed to disclose the inhibition in the first form that had been granted in favour of the liquidator of Atlas Appointments. Now, at one level, there is a difficulty, and that is that the solicitors who prepared the then memorandum for search instructed that search in the second form, Stephen John Tinsley. So when the searchers failed to find it, arguably they were fulfilling the instructions which they had received. However, looked at in a pragmatic sense, anyone would know that Steve was a diminutive for Stephen, whether Stephen was spelt with a V in the middle or with a PH. Not only did the interim report fail to disclose the inhibition, the completed search failed to do so as well. The letter of obligation granted by the selling agents was returned duly discharged, and everyone went along happily until the property was resold. Different searchers were instructed, and at that time the inhibition was detected. In the 1990s, the searchers, or the majority of searchers, private searchers, used the Soundex system which was used by Registers of Scotland. And certainly among searchers, it was understood that there were limitations in the searching system and its abilities to cope with diminutives of the nature of Steve from Stephen. In this case, First Scottish searchers had obtained that information from the keeper using the Soundex system, and as a result we can deduce that had the keeper been instructed to produce the same information, then the same result might have occurred. Now, while those limitations of the software that were used by Registers of Scotland and the majority of searchers, such limitations were not generally known by solicitors, and it's very unlikely that the general public were aware of these limitations either. It's worth looking at the history of the case because it was decided firstly at debate. It was heard in the Outer House before Lord McCluskey and then before the Second Division. And from those iterations of the case, the test of a reasonably competent searcher emerged. The case then proceeded to proof in the Outer House before Lord Penrose, and once again it was appealed, and the difficulties that occur here relate firstly to the duties of a reasonably competent searcher, but there's also a prior duty, and that is a duty on a creditor to bring to the notice of the public the inhibition. At this stage, before Lord Penrose, it was held that the creditor had failed to bring to the notice of third parties the existence of the inhibition by obtaining that inhibition in the name of Steve Tinsley. However, that decision was reversed on appeal to the First Division, and the test set out by Lord President Roger, as he then was the test of what was in paper copies, in other words, the official register of inhibitions and adjudications, rather than the electronic surrogate for that paper record. He took the view that what should have occurred was a test of professional responsibility, that a professional searcher ought to have consulted the original record, the Register of Inhibitions in paper quality. In doing so, the reasonably competent searcher would have used the indices. The name Tinsley would have appeared in the indices, and when that entry was looked up, it would be seen to be Steve Tinsley, which was sufficiently close to Stephen John Tinsley for a reasonably competent searcher to make further inquiry, particularly where the address matched the address that was sought. So, according to the Inner House in that case, the test was whether no reasonably competent searcher would have followed that particular course of action. Evidence was produced in the case in the hearing before Lord Penrose, not only from First Scottish, but also from other searchers. And unfortunately for First Scottish's case, because although the case is not with them directly as a party, they were clearly the party who was going to be funding the litigation and would end up being liable for the damages. Miller and Bryce said they were well aware of the difficulties and they used other methods to prevent that particular problem occurring. Therefore, it couldn't be established that First Scottish searchers were following the course of action that a reasonably competent searcher would always have undertaken in those circumstances. So from that we can see two things. Just to summarise, the duty on a creditor to reasonably bring the inhibition to the notice of the public by registering it in the personal register under such name as is appropriate. In this case, it was held that Steve Tinsley was sufficiently appropriate. As a separate issue, it might be worth exploring whether the keeper incurs any liability. Now, clearly the keeper's liability attaches to official records. So if the keeper, for some reason, failed to include in the Register of Inhibitions an inhibition that was properly submitted to her, then that might be a course of action that would give rise to liability. But is the keeper liable for unofficial information supplied to and relied on by third parties? Well, we can look at the principle in Hedley Byrne against Heller and Partners, 1964 appeal cases at 465, and also the modification of the Headley-Byrne rule that we can find in Caparo Industries against Dickman, 1990, 2 appeal cases, 605, and we can think about in Headley-Byrne contracting out of liability. So there's a further test. Is it reasonable to contract out of liability in any information that you supply? The Unfair Contract Terms Act continues to apply in relation to commercial, if not consumer contracts, and the test is one of reasonableness in all the circumstances. In a case in 2009, Brays against the Keeper, 2009, Court of Session Outer House at 176, it was conceded by the Keeper that there may be liability at common law, but in the case it wasn't established that there was any such liability in the circumstances. Another attempt was made in Santander against the Keeper in 2013, Court of Session Outer House 24, to have the Keeper found liable in respect of the information in the registers, or in this case, in accepting a discharge of a standard security for registration, and thereby inducing Santander to lend on the security of property where in fact there was a prior security extant. What happened was that the debtor in this particular case attended in person at registers to present to them a discharge of their existing Bank of Scotland security, which they had fraudulently prepared. So, a little more about the idea of the duty of the creditor to identify the debtor. And this case isn't an inhibition case at all. Inhibition cases are fairly thin on the ground. This is a much earlier case going back to the beginning of the 20th century in relation to an arrestment. In Latimer against Singleton Dunn and Company, there were issues regarding contributories in the winding up of a company where two shareholders were Ralph and Robert Latimer. Now, a charge was served and an arrestment served on R. Latimer, and the case was subsequently brought by one of the brothers who both lived at the same address, or both had business at the same address in St. Petersburg, and it was held by the court that the arrestment was not effective, as it was not clear from the face of the arrestment which of those two brothers were affected by the action in question. So we can see from that the effectiveness of an inhibition may depend on extrinsic circumstances. And I can recall around 30 years ago having cause to argue that where a father and son who both resided at the same address and both had the same name, that the inhibition that was served was completely ineffective. And I have to say, on the citation of that authority, the creditor accepted that the inhibition they had obtained was totally ineffective. The son, in fact, had, we discovered, obtained credit, and when we discovered that the credit was for a guitar and amplifier, we were fairly sure it wasn't the father who was implicit in the failure to repay the debt. So we need some sort of certainty in property transactions, but the ability of someone to adopt a different name makes it somewhat difficult to be absolutely sure that an inhibition is effective or ineffective. Money laundering requirements clearly make it far more difficult for someone simply to adopt a new name unless they can produce evidence that satisfies money laundering requirements then a simple change of name will no longer be sufficient. So at once this universal nature of inhibition, touching all heritage owned by a debtor, is its strength, but the failure to refer it to any specific property, and therefore having to make judgments as to whether someone is or is not the person in the inhibition, shows that there is an element of art in the job of searching, and particularly in relation to commercial and personal identities, has caused problems, as was seen in the Tinsley litigation. So if someone relies on the register, the position has now changed and has taken on board criticisms that were made back in the 1980s by Professor Gretton in his book on inhibitions, that if a party relies on the register, then they ought to be able to rely on the register and not find their title subject to reduction, as the sub-purchasers from Tinsley discovered in that particular litigation. So an amendment to the situation was made by Section 146 of the Bankruptcy and Diligence Scotland Act, which provides that a third party acquires the property or a right in a property, such as a security, so a creditor is protected, then the inhibition will cease to have effect if and only if the person who relies on the register is in good faith and has given adequate consideration. Now, the Bankruptcy and Diligence Scotland Act 2007 is based on a report on diligence by the Scottish Law Commission, number 183. When we look at their recommendation, 95, there the Commission required that to be in good faith, the third party who relies on the register is not aware of the inhibition and has taken reasonable steps to discover it. In other words, has instructed a search in appropriate terms. You'll note that that is different from the terms of the Act. The Act does not implement the bill attached to the report exactly and adds a new requirement of adequate consideration. So in most cases, in a purchase and sale transaction or a security transaction, there will be adequate consideration, but in a gift where there is no consideration, the donee will not be protected under the terms of Section 146 as enacted. So that brings to an end this section, and will then pass on to the third section, which will deal with the liability of searchers. Thank you.